In this personal injury action arising out of a motor vehicle accident, defendant moved for summary judgment dismissing the complaint on the ground that plaintiff did not sustain a serious injury within the meaning of insurance law section 5102D. Supreme Court partially denied the motion dismissing plaintiff's claim for lost in earnings, and defendant now appeals. Defendant met his initial burden of showing that plaintiff, a 46-year-old logger with a history of chronic back pain, suffered no serious injury causally related to the accident by submitting the affidavit of James Story, the neurologist who conducted an independent medical examination of plaintiff. Story opined that plaintiff's degenerative disc disease and mild disc bulging had pre-existed the accident, and he found no objective evidence that the accident caused or aggravated those conditions. As to plaintiff's claims that the accident caused him to suffer a stroke approximately 3 months later, and this stroke constitutes a qualifying serious injury, Story opined that no acute stroke occurred after the accident. He explained that while plaintiff had presented with some sort of acute symptomatic event, there was no evidence of recent neurologic injury. Instead, the brain lesions observed by MRI scan were old, and the mild residual neurological deficits were the result of a cerebellar stroke that plaintiff had suffered many years before the accident. This evidence was sufficient to shift the burden to plaintiff to come forward with competent medical evidence, creating a triable issue of fact as to the existence of a serious injury. See John versus Engel, 2, Appellate Division 3rd, 1027, 1028, 768, New York Supplement 2nd, 527, 2003. Davis versus Evan, 304, Appellate Division 2nd, 1023, 1024, 1025, 758, New York Supplement 2nd, 203, 2003. Plaintiff's efforts to meet this burden are unavailing. The reports of his treating and consulting physicians do not opine that the observed conditions of his spine were caused by the accident, nor did plaintiff's physicians identify the diagnostic tests that they had performed or provide any other objective medical basis for their non-observable findings with regard to his spine. See Temple versus Doherty, 301, Appellate Division 2nd, 979, 981 to 982, 755, New York Supplement 2nd, 448, 2003, Gillick versus Knights, 279, Appellate Division 2nd, 752, 719, New York Supplement 2nd, 335, 2001. Plaintiffs claim that the post-accident stroke constitutes a serious injury within the meaning of the insurance law is also unavailing. The physicians who examined plaintiff regarding a pre-existing atrial septal defect or hole in his heart discovered after the stroke opine that the accident caused an embolus, which was able to cross from his lower circulatory system through the hole in his heart to his upper circulatory system, and in turn cause the stroke. They do not, however, opine that the stroke caused a permanent or significant impairment of a body part, function, or system. Plaintiff concedes that the stroke symptoms did not persist, and he does not rely on them here, arguing instead that the necessity to either take anticoagulants and give up his work as a logger due to the risk of uncontrollable bleeding or abstain from anticoagulants and run the risk of a future stroke is itself a physical limitation constituting a serious injury. We are not persuaded. Given plaintiff's history of a neurological event suffered many years before the accident, Lattice states that he would have to treat plaintiff as if the atrial septal defect were the culprit, and he offers the alternative of a surgical repair of that defect. His alternative recommendation of surgical repair indicates that the heart defect and not the post-accident stroke created the need to use anticoagulants. Thus, Supreme Court erred in failing to grant defendant's motion for summary judgment in its entirety.